Ms. Weisenthal, are you ready to begin?
I am.
Thank you. Good morning. We're now on the record. It is 9 a.m. on Tuesday, September 12th, 2023. This is a public comment hearing in proceeding number 22R-0249G in the matter of the proposed rules regarding transmission utility participation in organized wholesale markets. My name is Eric Blank, and I'm the hearing commissioner for this rulemaking. The hearing is being webcast on the internet, and a court reporter is transcribing all oral comments for the rulemaking record. As stated in a prior decision, this rulemaking hearing will involve two panels. The first will be the three transmission utilities, and the second panel will be a subset of the participants proposing the process framework. I'm thinking maybe each of the panels might take 20 or 30 minutes. I also understand that other participants wish to give comments, and we certainly want to hear from everybody. So I propose we start with the panels and then open up things for other comments. Again, I'm hoping we can end before noon. I'd also request that individual commenters keep their comments concise so that everyone has an opportunity to speak today. Written comments are also welcome and accorded the same weight as oral ones. Written comment can be submitted on our e-filings website through our online form or by sending them to Dora_PUC_website at state.co.us. If using any of these methods, please specify the comments apply to proceeding number 22R-0249E. After the rulemaking hearing, we will issue a written order setting dates for another round of comments, including red line rule changes. Maybe with due dates of October 10th and November 7th, but we'll see. Before we start, any opening remarks from Ms. O'Neill, counsel, Mr. Davis? Ms. O'Neill? We'll assume silence is assent. And I guess with that, let's jump over to the utility panel. Mr. Taylor, Mr. Harrington, Mr. Pascucci.
Good morning, Mr. Chairman. I'm Mike Pascucci on behalf of Public Service Company of Colorado. With me today is Mr. Joe Taylor, our Senior Director of Western Markets for Public Service Company of Colorado, who will be speaking on behalf of the Joint Utilities, Public Service, Tri-State, Generation and Transmission, and Black Hills Energy.
Excellent. Would you like to start us off?
Sure. Yeah, thank you again for this opportunity to speak on behalf of the utilities. We'd like to start first by outlining that we've been guided by a set of principles, and we believe these principles are reflected by the requirements set forth in SB 21072. Those principles are that any regulatory process should be a single, streamlined process that's applicable to all of the utilities, that decisions be focused on whether an organized wholesale market meets the statutory requirements for an organized wholesale market, that decisions and process avoid predeterminations of which type of organized wholesale market is preferable, that the decision to join an organized wholesale market is the decision of the utility, and that there are certain matters that are subject to oversight by the Federal Energy Regulatory Commission. With those principles in mind, the utilities are appreciative of the fact that the Commission and stakeholders have an interest in what organized wholesale market the utility wants to participate in, and that there are unique interests that guide many of our stakeholders. Therefore, we've developed a compromise proposal that we believe incorporates many of the recommendations of the joint commenters, as well as the utilities, and achieves this single streamlined process with a focus on transparency and engagement with the Commission. Before I walk through that process, though, I'd like to pause for a minute and just talk about the concept of engagement. The utilities have heard the Commission loud and clear that engagement with stakeholders is desirable. We regularly engage with our stakeholders prior to and after we make major filings, and informally throughout the year to talk about general topics of interest with our stakeholders. We have every expectation that this will continue, and we will continue robust engagement throughout our process of identifying and participating in organized wholesale markets. What the utilities do want to caution against is the development of any prescriptive rules that determine the type, frequency, or agendas for any stakeholder engagement. Each utility will have its own unique pathway that it will follow towards participation in an organized wholesale market, and engagement should reflect the fact that the utility must provide value in those engagements and should not be predetermined as to what information they need to provide because it may not be available at that time. With that, I'd like to turn now to what we believe is an appropriate process. As I noted earlier, much of this process incorporates many of the comments provided by the joint commenters as well as the joint utilities. And we presented this process to the joint commenters on September 1st. During that meeting, we requested feedback or any modifications the joint commenters would like to receive. But as of yesterday, we have received no specific modifications or alternative proposals to that process. So with that, I'll ask, is it acceptable if I share my screen? I have a process flow diagram that I thought might be helpful as I walk through the process to share.
Yeah, that'd be great. And if our team, Ms. Federico, you can help Mr. Pascucci do that, that'd be great. Let's see if you can do that.
Yes, I've already made him a co-host, so you should be all set. There's a button at the bottom of the Zoom that says share screen, and you should be able to share anything you'd like using that button.
Great, thank you very much. Let me try it. Great. Can you all see my screen? And do I need to zoom in a little bit or make any adjustments?
Yeah, if you can make it a little larger, that'd be great.
Absolutely. Yeah, that's a good idea. Is this better?
There you go. Perfect.
So thank you again. This is just an overview of our process. First step in this process is the filing of annual status reports. As I noted earlier, again, engagement, transparency are important to the utilities. We understand it's important to the commission and our stakeholders as well. So these annual status reports will be filed by June 1st of each year prior to a utility filing either this application for cost recovery and shared savings or informational notice of participation, which I'll address further in just a moment. These annual status reports would include an identification of any regional electricity market in which the utility is currently a member and the date at which membership began, identification of each regional electricity market which the utility is currently considering joining, including whether that organized wholesale market is an RTO, ISO, day-ahead market, or other market structure. Included in that would be a discussion of the key features of that market or those markets if there's more than one. A description of the utility's efforts to join the organized wholesale market by January 1st, 2030, including updates to the activities previously discussed in prior reports, if applicable. And by June 1st, 2028, in that report, the utility, if it's required, would have to indicate whether or not it expects to file a waiver for delay or a waiver for delay of the requirement to join an organized wholesale market by January 1st, 2030. So this is that annual status report step right here, step one of the process. Moving next to step two, the request for declaratory order. This process, again, compromise position. We've adopted many of the recommendations of the joint commenters in this request for declaratory order with very minor modifications to it. In this step, the utility or a joint utilities could file a request for declaratory order with the commission. They would be required in that request for declaratory order to outline how the organized wholesale market meets the 10 characteristics outlined in section 40-5-108, 1A. The declaratory order would then allow for a 60-day comment period from stakeholders. And at the end of that, a 180-day period for the commission to make a determination as to whether the request for declaratory order is approved, meaning that the organized wholesale market meets the statutory requirements. This 180-day period can be seen as abrupt relative to our normal adjudicated proceeding schedule, but the utilities believe it's important for a speedy determination because it allows for the utilities to either pivot if the commission denies the request for declaratory order or advance their engagements with organized wholesale markets. When I say pivot, my thought is our thought is if a commission denies the request for declaratory order, it allows the utilities to stop investing in that organized wholesale market and move on to alternatives, or to go back to that organized wholesale market with feedback from the commission and continue negotiations and discussions with that organized wholesale market to determine how it could qualify. Before I move on to step 3, there are a couple additional notes I'd like to make around the request for declaratory order. First, the utilities envisioned that because we're all on different pathways right now and our process for joining organized wholesale markets may differ, for administrative efficiency, we believe it's appropriate that an approved request for declaratory order should be transferable to any other utility. In other words, should, as an example, public service file a request for declaratory order and the commission approve it, at its own volition, Black Hills or Tri-State could adopt that decision and could continue negotiations or begin negotiations with that organized wholesale market without filing its own request for declaratory order. Similarly, I'd like to note that in any request for declaratory order, if it's approved or denied, that should not be a predetermination on whether the utility can or cannot join that organized wholesale market. By that, I mean that if a declaratory order is approved, the utility should not be required to then join that organized wholesale market. The declaratory order process simply affirms that that market does meet the statutory requirements. It doesn't mean that that market is in the public interest or is in the best interest of the utility's customers to participate in. That allows us the flexibility to continue negotiations and investigations, but also continue looking at other options for our customers. Similarly, should it be denied, it does not foreclose any future opportunity for that organized wholesale market. It just affords the utility the opportunity to go back and engage in further negotiation or discussion, as I've mentioned. With that kind of negotiation discussion in mind, if it is denied, we do believe it's appropriate that the utilities have to pause for 180 days to allow a cooling off period, to allow new information to be developed, new modifications to be made before a utility can come back with a request for declaratory order for the same market structure. Moving next, assuming that your declaratory order is approved, the question is whether a utility is rate regulated or not. In this case, non-rate regulated utility being Tri-State. And I'll move through this one first. If it is not rate regulated, Tri-State or a non-rate regulated utility would be required to file an informational notice of participation. That informational notice of participation would inform the commission and stakeholders that that utility intends to join a organized wholesale market previously approved under a request for declaratory order and would provide that information to the parties. Alternatively, for rate-regulated utilities, they would be required to file an application for cost recovery and shared savings. This application would mimic very closely what Black Hills and Public Service have recently filed to request participation in the Southwest Power Pool Western Energy Imbalance Service. It would also address the need for the shared saving mechanism defined by proposed rule 3757. Should the commission deny that application, the utility would again have that cooling off period of 180 days. That would allow the utility time to, one, reevaluate its participation in that market, as well as engage with stakeholders and the organized wholesale market to make modifications to its request. Should the utility receive approval of their application for cost recovery and shared savings, that would move us into step 4 in this process, which is the filing of status reports. This process is applicable to both rate regulated and non-regulated utilities, and it would require at least one status report be filed. The status report would address issues such as the progress, the key milestones that the utility has achieved in its integration and participation in a wholesale market. And for the rate regulated utilities would include a reflection of the actual costs incurred in its participation or integration into an organized wholesale market, as well as relative to its expected costs. Additional reporting requirements may be included and could be determined through that application for cost recovery and shared savings as well. With that, I would like to pause and reflect one other issue or one other process here that I haven't talked about, which is this request for waiver of delay. And you'll see I've noted it in several different places on the flow chart here. The statute obviously envisions that there is a possibility for a request for waiver or delay. And the utilities believe that that request can be made at any point in the process. That includes after a request for declaratory order has been approved. The thought in that being that just because, again, a declaratory order has been approved and an organized wholesale market is determined to meet the statutory criteria, doesn't mean that that market is in the public interest or is in the interest of the utility's customers. And so utilities should still be afforded the opportunity to seek a waiver or delay in order to identify the best wholesale market for its customers, not any wholesale market. So with that, what I would like to do is just note that as I've outlined here, the utilities have developed what we think is a compromise process, again, incorporating many of the recommendations of the joint commenters and the joint utilities. As you've noted, the next round of this will be blue lines, and the utilities are available to file blue lines, incorporating this process for the commission and making recommendations as to how to facilitate it, with a focus in the next round as to the specific requirements of the request for declaratory order and the application and informational notice of participation. By that, I mean, what are the specific requirements of those? With that, I think I can wrap up my comments. I thank you again for the opportunity to present today, and we're available to answer any questions you may have.
Well, I appreciate the new proposal to bridge what seemed to me was a significant gap between the utilities and the other parties. So thank you, and very much look forward to hearing from the joint commenters. Before we do, would Tri-State or Black Hills like to add anything, share further comments on either this proposal or anything else?
Thanks, Chair. This is Dietrich Hefner, outside counsel for Tri-State. I think Mr. Pascucci covered all the points that we had, but we're certainly here and available to take questions or engage in further discussion as may be helpful.
Appreciate that. Mr. Harrington.
Likewise, good morning, Mr. Chairman. I don't have anything else to add. We worked with Excel on this presentation, and we don't have anything else to add. Thank you.
Thank you, sir. Unless there's anything else from the utilities, I'd like to turn it over to the non-utility parties. And I don't know if you're organized with a lead commenter, or if you just want to have people raise their hands or turn on the video, and we'll go down that way. And I'll just do it in the order, unless you guys want to do something different. I just start in the order in which people turn their camera on. So Mr. Fanyo, you want to get us started?
Thank you, Chair Blank. I'm Rick Fanyo. I'm attorney for Climax Molybdenum Company. It's one of the members of the joint commenters. We intend for me to introduce this and also conclude, and in the interim, we'll have Parks Barroso of WRA, Brian Turner of Advanced Energy United, and Chris Legere of Interwest make presentations on elements of our proposal. The joint commenters are a group of 13 interested parties with varying perspectives on this OWM rulemaking and transition. The members are listed in our various prior filing, but quickly go over them. Advanced Energy United, Clean Energy Buyers Association, Colorado Energy Consumers, Colorado Energy Office, Colorado Office of Utility Consumer Advocate, Colorado Solar and Storage Association, Interwest Energy Alliance, Signal Tech Coalition, the Solar Energy and Industries Association, the Sustainable FERC Project, the Western Grid Group, and Western Resource Advocates. As you, from this list, I'm sure that it's clear that we have groups representing many perspectives, various consumer interests, various developer interests, and various environmental and renewable energy advocates, as well as various other public interest groups. It was that effort to address what we think is an appropriate process that led us to get together and come up with the process framework that we submitted, I guess it was back in January. Excuse me. The utilities presentation is, I think, progress in this rulemaking. They did meet with us at our request about a week and a half ago and presented the flow chart. We've reviewed that, and while we think it's progress, we think there are still some deficiencies, particularly on the public engagement process and on the nature of the decisions and applications that would be submitted to the commission for a decision. It's important at the outset to understand, I think, how significant change to utilities who are joining organized wholesale markets will be. This is a substantial change in the manner of delivering utility service, as well as in the manner of regulation. A good deal of the control over the transmission system and the provision of electricity through a market mechanism organized by an RTO is considerably different than we have today, at least with respect to the retail utilities. Understand that Tri-State is already a member of SPP and the Eastern Interconnect to a certain extent. That is a major change, and it's probably irreversible. Not to say that a utility couldn't remove itself from an RTO, but that would be a very difficult and expensive process. With that change, the SB 72 presents two decisions for the commission to make. Two fundamental decisions. The first is whether an RTO or ISO, whatever it may be, meets the 10 criteria in the statute. That's the declaratory order process that Mr. Pascucci mentioned as step 2. The second decision is whether assuming a qualified OWM, a transmission utility that proposes to join it would the result of joining would be in the public interest and result in just and reasonable service and rates. Those two decisions, qualification of the OWM and the public interest in a particular utility joining an OWM, are the key decisions the commission has to make. The purpose, and these involve a great deal of factual, legal, and policy issues that need to be determined in order to make each of those decisions. All we have to do is look at criteria number 10 in the OWM qualification list, and you see it covers just about everything. But overall, the purpose of the OWM is to coordinate and efficiently manage the dispatch and transmission of electricity among public utilities in a multi-state or regional basis. So this is a very substantial change in both the manner of delivering electricity to customers and in the manner of regulation, since that multi-state operation is primarily subject to FERC jurisdiction and less so to the state utility commissions. The purpose of these rules should be to create a process that is inclusive, thorough, and provides a record that would support the commission's decision on the two issues. In our view, in order to do that, the process needs to be adjudicatory. And that means that there's an application, there's testimony, there's discovery, there's cross-examination, there are briefs, and then the commission deliberates. Without that, we don't have the kind of thorough, transparent, and complete investigation into what the consequences of for the public interest in Colorado, including the policy issues of emission controls or emission reduction, how those issues will be affected, and how it will advance not only the public policy goals, but also the interests of consumers and utilities. We came up with a 3-stage process. The first is, we call it stakeholder meetings, public participation, how you can call it whatever you like. But it would be a series of a series of meetings to inform the public. Second would be the declaratory order process and adjudication on the issues of whether the 10 criteria are met by a particular OWM. And the third would be an adjudication on whether a particular utility joining a particular qualified OWM would be in the public interest. Now, Mr. Barroso for WRA is prepared to, and along with Brian Turner of the Advanced Energy United, will address the first step. Mr. Legier will address the second, and I'll come back and address the third, but I will say before I turn it over to them, the utilities proposal is definitely progress. Where the deficiencies lie, I think, are in the public participation and transparency process elements. They speak of status reports at the first stage, which are wonderful to have, but there's no feedback, no stakeholder meetings, no commission information meetings, no technical conferences. It's just, here's our report. You can take a look at it and see what you think, and we'll send you another one in a year. The second is a deficiency is that the DO process is just a paper process. Again, no investigation of all the many factual, legal and policy issues, except that are involved in qualified an OWM as or RTO as an OWM. That's where we think the adjudicatory process is needed. And the third is the application for to the commission is at the third stage is just for approval of cost recovery and shared savings. Those are important issues, but they don't include whether joining an OWM by a utility is in the public interest and will result in just reasonable rates and service. Those, at least as I see it, I think as we see it, are the deficiencies in their proposal. With that, I will turn it over to Mr. Barroso, and then he will be followed by Mr. Turner and then Mr. Wisher.
Mr. Barroso.
Great. Thank you, Rick, for that great introduction. My name is Parks Barroso on behalf of WRA, and I'm going to provide a little more background on step one of the Joint Commoners proposed process. So like Rick mentioned, the step one is really centered around stakeholder engagement and information sharing. It's designed to create transparency and to inform the commission and interested stakeholders of developments around OWM formation and implementation, the utility's intent to join an OWM and anticipated procedural steps, and to allow for technical discussions around the aspects of the OWM offerings available. And I just want to reiterate here Rick's point from the beginning, which is that we're talking about a paradigm shift in utility operation regulation, which only enhances the need for robust stakeholder engagement and a positive feedback loop. As with other phases of the Joint Commoners proposed framework, the hope here is that early and earnest engagement can create procedural efficiencies well before utility reaches the point of entering an OWM. As to timing, the step one would start as soon as practicable. It would involve periodic utility status report filings, followed by technical conferences, stakeholder meetings, and/or commissioner information meetings. And the Joint Commoners are flexible as to the frequency of those reports and the follow-on meetings. But really, this step one is intended to balance two things. On the one hand, the commission and stakeholders' need for information, need for an opportunity to ask questions and provide recommendations, and to develop familiarity and comfort with the different market offerings being pursued. And on the other hand, it's designed to balance the utility's desire for a known and workable process. And I'll note here that for a variety of planning processes in Colorado, utilities already convene stakeholders on a quarterly or even more frequent basis, such as for res plan implementation or DSM programming. Given the magnitude of the market-related decisions at issue here, it's reasonable to create rules that have a structure that has at least a similar level of recurring engagement. As to the technical conferences and meetings that would follow the utility status reports, those would be designed to facilitate a comprehensive understanding among the non-utility parties. Parties would have the opportunity to understand developments around various market offerings and how the utilities themselves are evaluating the pros and cons of those offerings. The intent here is to create meetings that are not tied to a litigated proceeding or are in any way adversarial, but rather to create the opportunity for parties to become informed as to the timing and substance of those potential market offerings, as well as to have the opportunity for commission stakeholders to ask questions, suggest topics for further elaboration, and to provide a forum where stakeholders could offer feedback and share their perspective. This is a form of collaboration that the Commission has encouraged and viewed as beneficial in numerous proceedings and across a wide range of issues. And to conclude here, and as discussed previously, the intent of this phase is really to allow the utilities the opportunity to help drive consensus. The Joint Commoners believe that it's in the interest of both the utilities and the Commission to have a successful stakeholder engagement process. Doing so could help generate good faith among the various groups. And crucially, it could help to resolve or narrow the issues in advance of what might be contentious future time-sensitive litigated proceedings. I'll pause here and pass it to my colleague Brian to discuss the range of topics that might be considered in this step one.
Mr. Turner.
Thank you, Mr. Chairman. Good morning. And thank you to Mr. Fanio and Mr. Barroso for setting up this conversation. I would like to expand on their point about the significance of the change that entry into an organized wholesale market represents, and discuss some of the issues that we believe would be at play, not only in addressing the 10 criteria of SB 72, but also in the determination of whether the entry of a utility into a market will result in just and reasonable service and rates, and also would be in the public interest. The range of these issues illustrate the significance of the change. And we would hope to explore these issues in the reports, meetings, workshops prior to entering into the declaratory order or application phase to settle the majority of issues that we can prior to those stages. So some of the issues that we see is very important to discuss as soon as possible and ongoing would be how the market operator is managed and run and by whom. Of course, the board oversight, the governance of the organized wholesale market, how the board is determined, how seated, and how oversight is exercised, the role of state policymakers and state policies, and how state policies and priorities will be protected, the representation and voting rights for both transmission owner and non-transmission owner members, and how other stakeholders are represented or considered in decision-making. There's a whole set of issues about the actual market design and operations that should be discussed, including how generator and load bids will be offered and lifted, how aggregated distributed resources and demand response resources can participate, how congestion is managed and priced, how ancillary services are compensated, the market monitor function, and how seams with external balancing authorities will be managed. Another broad topic is resource adequacy, the mechanisms used to determine and satisfy resource adequacy. Of course, new generation interconnection procedures. A whole basket of issues around transmission planning, transmission project selection, transmission cost allocation. We would like to address the existing transmission tariffs across members and how they will be unified and allocated in a organized wholesale market. And of course, emissions tracking and policy. And find how the market footprint affects resource costs, availability, and other energy resource plan goals and planning. And finally, of course, the expected investment and ongoing operational costs and anticipated cost recovery. So with that discussion of the broad range of issues that we see is in play in making those determinations regarding not just the 10 criteria, but also the public interest in just and reasonable. I'll turn it over to Chris Leger to discuss the declaratory order stage.
Mr. Leger.
Yes, thank you, Mr. Chairman. My name is Chris Leger, and I represent the Interwest Energy Alliance. I think it is important to reinforce the understanding that at least renewable developers enthusiastically support the development of expanded markets and enthusiastically support the development of commission implementing rules that grant certainty and predictability for OWM implementation in Colorado. We are very much aligned with the other stakeholders here in that we want the best market for Colorado and believe that the process that we've jointly outlined will give Colorado the best chance for success to achieve that goal. In phase 2, we have outlined the first binding process, the declaratory order or DO phase. Even though it has the same name as the phase presented earlier by the utilities, it is significantly different. This DO process is intended to get the commission involved as early as possible for factual determinations and to help streamline the eventual utility application. We see this DO process beginning at the filing at FERC by a market operator for approval of an RTO tariff or similar applicable in Colorado. The commission would then open a DO proceeding to determine, to the greatest extent possible, whether the proposed tariff meets the criteria of an OWM and as prescribed in SB 2172. Ideally, this proceeding would be opened by an application of one or more of the utilities who have an interest in joining that RTO. However, this proceeding could be initiated by any party, including the commission itself, if no utility made an application for a DO process. The idea is that once the structure of a potential OWM is known through that FERC tariff filing, the commission can begin the process of determining if it satisfies any or all of the OWM criteria. This process would be a fact-finding exercise and therefore requires an adjudicated proceeding. So this necessitates testimony and discovery. We do believe that the normal DO process will need to be modified to allow for sufficient fact-finding, and it will require sworn evidence to get and some amount of discovery and cross-examination for the commission to adequately adjudicate the extent and validity of the evidence presented. It also will require that all stakeholders have an opportunity to meaningfully and fully participate in that proceeding. From where we sit right now, we don't know if any of the OWM or all of the OWM criteria can be fully determined at this phase. But we are intentionally not limiting the phase to any specific subset of OWM criteria. If any party wants to advocate that a specific criteria is met at this stage, we welcome that. We further expect that a robust and meaningful stakeholder process, as described earlier, will significantly increase the level of agreement and thus reduce litigation here in phase 2. If any or all of the OWM criteria can be determined through this DO process, then the commission would make a factual finding that the market design is sufficient on those criteria. If the commission finds that certain OWM criteria are not met, or that the commission is unable to make a determination based upon the evidence presented, the commission may defer ruling on those elements until the application. The rationale for this DO process is simple. If there are components of a market that can be determined sufficient to meet the OWM criteria, it creates significant administrative efficiencies to deal with them at the earliest possible time. And in exactly the same way, if there are components of a market that may not sufficiently meet the OWM criteria, it creates clarity for the market operator and the utility to know this at the earliest possible time. The structure of the DO process should be applied to as many proposed RTOs as are active or present so that the utilities would have clarity around the suitability of their options at the earliest practical point in time. The result of this DO process will streamline the utility application, which Mr. Fanyo will now cover.
Mr. Fanyo.
Thank you, Chris. Utility proposal at step 3, as I mentioned earlier, is apparently limited to 2 questions. One is cost recovery of the utilities participation in an OWM, similar to how they handled the WISE applications. And 2, the shared savings issue that's set forth in the OWM statute. Notably absent is any question about whether joining the OWM is in the public interest. The statute doesn't require a commission approval to join. It's silent. Silence also means that it doesn't prohibit or foreclose the commission from deciding whether or not joining is in the public interest. The commission has, as you and your staff well know, because I've heard it so many times, broad authority over the utilities. Specifically in section 40-3-102, the commission, and I'll at least paraphrase here, is vested with the authority to generally supervise and regulate every utility in the state, whether specifically designated in the prior sections of the statute or not. And in addition, to do all things that are necessary or convenient in the exercise of that power. What we're dealing with here is a fundamental shift in the nature of generation and delivery and markets for electricity and the regulatory jurisdiction and mechanisms that will be applied to that. This is no small change. And yet, utility application says the only thing that is necessary is determination that the OWM meets the criteria and that the cost recovery and shared savings issues are addressed and approved or modified by the commission. Something as fundamental as this requires a full investigation and understanding and public input through an adjudicatory process. So that's where we differ very significantly from the utilities proposal. I think that will wrap it up for us.
Let me ask you a couple questions before opening it up to the broader public. Your last comments seem to suggest that the gap on the public interest determination is perhaps too big to bridge with the parties engaging in discussions on their own. Is that your view, Mr. Fanyo, Mr. Turner, Mr. Barresso, Mr. Leger? Does the commission have to resolve that issue, or do you think there's value in trying to encourage the parties to talk further? And if so, do you have any process suggestions for us about how we might facilitate those discussions, or do you just think the gap's too big?
My thought is that further discussions could be fruitful. Don't know that we bridge the gap. You never know when you're have a gap, whether further discussions will bridge it or partially so, or not at all. But I do think we have a good had a good dialogue with utilities 10 days ago, and I think we are, and they are still open to talking further. We have a significant difference there. I mean, cost recovery, by the way, advanced cost recovery, as the commission well knows from experience in the recent weeks or months and certainly years, cost recovery approval of estimated costs years in advance, it turns out to be a real problem. One, the estimates are not accurate. They can't be far in advance. And two, there is the buyer's remorse of having approved something that turns out not to be what you anticipated. So you're running into that in several places now. So that's not good enough for something as significant as significant changes such as this being allowed to go forward by the commission. It needs a determination of whether it's in the public interest. Now, the commission or the utilities, Mr. Pascucci said that the fact that an OWM is approved as to meet the criteria is not necessarily a decision or even a favorable indication that the utility will join it. That utility still would need to make its own determination about what they think is best, and they would do that with the best interest of the I guess the own utility, but also the customers in the state of Colorado in mind. The question is whether that is left only to the utilities. Or whether it's a decision for the commission with input from all the interested parties. What's best should not be a decision left solely to the utilities, with everybody else only addressing cost recovery and shared savings.
I think I understand your position, but before we get there, is there anything that we could do that would be helpful to help frame up a dialogue with the utilities to see if there's a middle path forward, or do you think that's not the way to go? And do you have any specific advice towards that we could do to help facilitate that discussion, Mr. Turner?
Yes, thank you, Mr. Chairman. I came up mute to address the two sides of the question. I heard you ask about the substance of the public interest at first, and whether there's a gap there between ourselves and the utilities. And then we also are talking about the process and agreement around the process. On the substance of the meeting,
I'm asking a prior question was, is there anything we can do on the rulemaking process to facilitate a dialogue and potential resolution in the coming weeks and months, not the broader process about how we, determine whether an OWM complies with the 10 statutory criteria or a full public interest determination. I'm asking, is there something we can do with a rulemaking process that would help bring the parties together? Or do you think the gap is too large to not make that worthwhile?
We have only had a limited opportunity to meet and discuss. We have made progress in that meeting and discussion. I think in particular, laying out the issues of relevance and the declaratory order stage, though we are separate in what is necessary to go into that stage. I think additional progress can be made.
I appreciate that. One question on the broader issue. Given that Markets Plus, SPP, RTO West, and CAISO EDAM are all regional processes, how do you see the Colorado-specific public interest determination you propose fitting into the regional decision-making? Especially on a timing perspective, given that the process framework asks us to initiate an adjudication within 30 days of an RTO entity filing for FERC approval, don't we need to be shaping the key tariff decisions prior to the FERC tariff filing? So I just have some real concerns on the timing and how what we do here influences the regional process. I'm just wondering if we need to play in the Markets Plus process, the SPP RTO West process, and CAISO EDAM, wherever we're going to be, and less focus on Colorado specific processes. But I just throw that out there. How does a Colorado specific process influence the regional process in a timely way? You're muted, Mr. Finney.
I think Mr. Barroso may have some good thoughts, and Mr. Legier as well. But I think the way it fits is step one of our process in advance of that filing. That stakeholder engagement, informational meetings, technical conferences are all designed to not only learn what is being considered, but also to have input and to possibly modify with suggestions. And the timing is certainly uncertain, but the idea is to have influence over what is filed at FERC and how the OWM is designed before it's set in stone. That's what step one's for. Mr. Barroso?
Yeah, I think Mr. Fanio put it well, which is that the timing of the step one process is to precede the tariff filing at FERC. And so there would be information sharing in both directions and recommendations from stakeholders, and the commission, who represented a variety of interests, would be able to flow upwards towards the market design prior to certain aspects being locked in, is the intent on timing there.
Mr. Turner.
Thank you. I would just add that Advanced Energy United is active in the several dockets in states that are considering entry into an OWM, and whose state officials and utilities are also active in the regional process. And so I'd just like to point out that these individual state dockets are influencing the regional process. So the first stage that we have outlined, for instance, I think would uncover and fill out information that would be of relevance and be part of influencing that regional discussion.
I appreciate it. Mr. Leger.
Yeah, thank you, Mr. Chairman. I would second what Mr. Turner just said. I think that the multiple parallel paths is a difficult maze to kind of understand, but I think it should not be at the detriment of the individual state processes. There's multiple state processes that are going on right now that we are participating in, as well as the regional processes. And I think it's important that this state also continues its process and doesn't leave anything on the table for what Colorado wants to see going forward. So I think all of the state processes really are influencing the regional processes, but I also think it's important that participating in the regional processes is just as important.
I appreciate that. Mr. Pascucci or the utilities, any thoughts on how to conduct this rulemaking process in a way that's fruitful to see if, I mean, it seems like there may be a significant potential agreement on the front end of the process, and that maybe a lot of disagreement about the public interest determination on the back end of the process. Maybe with some hope that with enough work up front, we can avoid a big fight at the end. Any thoughts on how to move this rulemaking process forward to encourage discussion among the parties? And I'll come back to you in a second, Mr. Finn.
Yeah, thank you for the question, Mr. Chairman. I do think the utilities are willing to continue engagement discussion with the joint commenters. We certainly had that first meeting. We agree it was a good meeting. What I think to the question of how the commission can help influence this, I think the utilities would encourage the commission to encourage compromise on all sides. As I've noted, we've adopted and moved our position, adopted many of the joint commenters' proposals already, modified our own proposals. Speaking on behalf of the utilities, I don't know that I have seen compromise or shifting of positions from the joint commenters at this point. Understanding that their specific focus is on the public interest and how further adjudication can be done, we can certainly take that back and think about it. But I would also like to see agreement or compromise amongst all the parties, not just compromise from the utilities.
Mr. Fania, did you have a response? I saw you had your hand up.
Yes, I was going back to your point that Mr. Pascucci just addressed, which is there value in further negotiations, room for compromise, particularly on the public interest issue and how that's determined, and what the commission might do to facilitate that. When any guidance the commission, I guess you as a hearing commissioner could give on whether the ultimate decision about joining is limited to cost recovery and shared savings, or whether it also will necessarily include an inquiry and decision on the public interest. Any guidance whether you think public interest is included in that final stage decision by the commission would be helpful, because it would tell us, it would tell the joint commenters, if you say no, there's no point in pursuing that. If you say yes, that's an issue that needs to be addressed. Tell the utilities that we should be talking about the scope and timing and other details of how that would be addressed. So that's my suggestion.
Let me ask you a question along those lines. Given that Tri-State operates in multiple states with load and generation on both sides of the asynchronous divide, is a nonprofit co-op, is on a significantly more accelerated schedule to join an OWM, and that this commission doesn't have rate jurisdiction. For purposes of that public interest determination, should we be treating Tri-State differently than the IOUs?
You've ticked off the list of distinctions between Tri-State and the IOUs that I've had on my list here for months, and thinking about that very question. There's no doubt that those differences, I think, require some different approaches to Tri-State than the others. And I think that those differences can be accommodated within the structure of the process framework that we've provided, not by having a separate addendum that says this applies to Tri-State, not to the others, but rather having including in the rules some modified procedures, accelerated, however you want to put it, whatever, modified criteria, procedures, criteria, and other terms that that fit Tri-State situation. We clearly understand that that it's in a different position than the other two.
I'm just wondering, as I listen to this discussion go back and forth between the utilities, if there's a way by distinguishing between Tri-State and the IOUs, and maybe if there's a way of strengthening the cost recovery adjudication to make more of a public interest determination as part of that. There's a way to sort of bridge the gap. Mr. Turner.
Thank you, Mr. Chairman. I just wanted to address the issues that you raised regarding the difference between Tri-State and the other utilities. And we recognize the difference in the regulatory treatment of the utilities. But a couple of notes that I'll make is that one, Tri-State is a transmission utility as designated under SB 72. And so subject to the same treatment that law requires, excepting the rate regulation aspects. And two, subject to several other public interest statutes in the state of California, such as energy resource planning. And the question of the operational impacts of Tri-State's status, current footprint in the two interconnections is a factual question. Does it matter, and how does it matter that the utility spans the interconnections, and how does that affect then its statutory responsibilities under, for instance, energy resource planning? That is one of the questions that we would really like to explore in a public setting to help you determine the degree of oversight that you need to make to that decision, how it affects those public interests.
And can that be done up front, or does it require an after the fact adjudication?
I think that exploring that up front is exactly what we would like to do to determine whether an adjudication is necessary. I don't have a opinion on that.
Just open it up back to the utilities to see if you have any comments, Mr. Pascucci, Mr. Hefner, or Mr. Harrington, before I try and solicit comments from the broader public. Mr. Hefner?
Yeah, thank you, Chair. Just briefly on the subject of Tri-State, I think we obviously agree that Tri-State is different, and the cost recovery components shouldn't apply and don't apply under the statute. I think the other point I would make is you have pretty clear instruction from the General Assembly in the statute, and there's really only one place where they have talked about making a public interest determination, which is if a utility wants a waiver or delay. One of the ways they can obtain that is by making a showing that joining a market is not in the public interest. So I think from where we sit, we see the statute as essentially assuming in a lot of ways through the requirement to join by 2030 that joining an OWM that meets the 10 criteria is in fact in the public interest by default, and that if you would like to avoid that responsibility, it is incumbent on the utility to prove that the joining of an OWM is outside the public interest.
Mr. Demman or Mr. Pascucci?
Thank you, Your Honor. Trying to get my camera to turn on. There we go. I was going to make comments similar to what Mr. Hefner just made. I agree with what he said. I think some other points that you need to keep in mind as you evaluate the positions of Mr. Fanyo's group and the transmission utilities, you need to go back and actually look at the statute. Senate Bill 21-072, particularly Section 40-5-108, defines a specific way this commission is supposed to address regulating organized wholesale markets. And I heard in the discussion from Mr. Fanyo and his colleagues that they want to add things to the statute that just aren't there. The requirement of some sort of public interest determination, that is, that it's in the public interest for a transmission utility in Colorado to join an OWM is not in the statute. And as Mr. Hefner said, the only place the words public interest appear in that statute is in the waiver and delay section. And moreover, nothing in the statute requires the commission to make a determination that a utility's joining of an OWM will result in just and reasonable rates and service. So, I'm sure Your Honor is quite familiar with the rules of statutory construction. The commission just simply can't add things to a statute that specifies how the commission should regulate a particular thing when the legislature did not add those things to the statute. And I'll turn it over to my colleague, Mr. Pascucci, or the other utility representatives if they have something additional to say.
Mr. Chairman, I won't try to get into the statutory construction and legal requirements. Obviously, we have our lawyers for that. One thing I did want to comment on was the consideration of commissioner information meetings. I think to the extent the commission believes those are important, and certainly we understand your interest and engagement in this topic, we don't believe that commissioner information meetings need to be formalized in rules. The commission has the authority and the opportunity to hold commission information meetings whenever they deem appropriate and however they feel are necessary. My understanding is many of the parties on this call already engaged in discussions with a lot of the organized wholesale markets that would be under consideration for future participation. So there is some question of just duplication of efforts and how unique these engagements would be, given that many of the parties are already participating in this type of work with the regional markets already. So just want to, again, caution we're trying to focus as well on administrative efficiency of things and recognize the fact that with lots of participation and the commission's own ability to schedule things, how much a rule requirement provides additional value.
Appreciate that. Any other comments from the panel before I open it up more broadly? Is there anyone else who would like to speak? You could put up your hand. Mr. Sayal with WRA, you're up.
Thank you, Your Honor. Hello, Commissioner Cheblank. I'm grateful to the panel that engaged and the efforts we've had with the utilities as well to meet. I want to clarify one element around the declaratory order and the process that we have proposed. Is there has been history in the past of entities joining a certain organized market or an RTO, and it doesn't deliver the goals or the expectations that they had. So going through this process, which is adjudicated with an evidentiary hearing and stakeholder processes and meetings before, may sound like an undue burden earlier on, but it is a insurance policy you're investing in as you go into electing a certain OWM to join if it meets the criteria, so that if later you decide to step out of that market, you have a process that you've gone through and the basis that the entity can justify part of the exit requirements as well. So I'm looking at this not just from why we want it this way done well, but it also ensures you on the back end, if changes happen and a market design changes of a OWN that is not now complying with the OWN requirement, so the entity should be able to have the flexibility. So there is multiple benefits to the perspective, and I apologize if I already repeated anything that my panelists, colleagues already said on this matter. Thank you.
Appreciate it. Actually, before we go further, Ms. O'Neill, Ms. Rosati, Mr. Davis, any questions for the panel that you'd like to make, Ms. O'Neill, or comments?
Yeah, I don't have anything additional, yes, and apologize for earlier.
No worries. Ms. Rosati?
No, Chair, no questions from me.
All right. Is there anyone else who'd like to speak at this point? Ms. Glustrom.
Thank you very much, Mr. Chairman. I had no intention of speaking really, but I think the question of public interest is more than well covered in the Commission's general statutory authority. So I don't think the legislature needed to put it back in because it was covered in so many ways under the Constitution, under all of Chapter 40. I didn't prepare the remarks, but I find it a little whatever that somehow the Commission doesn't have the authority to determine something in the public interest. So I appreciate that opportunity. Thank you for holding this hearing.
I think Mr. Fanyo made the same point, so I appreciate it. Anybody else like to speak? Mr. Turner?
Yes, thank you, Mr. Chairman. I just wanted to take this opportunity to speak on behalf of Advanced Energy United to thank you for your leadership on this topic. Advanced Energy United is strongly supportive of regional wholesale energy markets, transmission organization, regional transmission organizations, et cetera. We're just recognizing the broad range of interests that are represented by making this choice. And so this is why we support the strong process that we put forward. And rather reiterating my point in a way about the leadership that Colorado is exercising in developing this proceeding has a substantial impact on that regional process and the views and attractiveness with which other states and other utilities view joining the available wholesale market options. So just wanted to underscore the role that this proceeding, your leadership, Colorado's leadership, has in developing Western energy market options, which we believe will have substantial positive impacts for the advanced energy industry in Colorado and beyond.
Well, while you're there, what I heard today gives me some optimism that on the front end, we can agree on some processes to flesh out these issues and, sort of raise Colorado concerns, identify and raise them more broadly in the regional process. So I think I have some optimism from today that we can bridge the gap on the front end. On the back end, I'm just wondering that if we distinguish between the IOUs in tri-state, and if we flesh out that cost recovery proposal somewhere between cost recovery and a full public interest determination, if there's some form of middle ground that also distinguishes between the IOUs and tri-state. Any guidance on trying to find that middle ground on both either the front end or the back end?
Well, I agree with you that I think that we're making progress and that there's reason to be optimism on the front end. regarding the breadth of issues and where the public interest lies within them. And I think that actually we'll find that we share a lot of orientation on those public interest questions, and that there's more agreement than not. But I also agree with you that there is a still remaining gap on the latter part about what commission authorization is required at what point. And frankly, I think that it's time to get down to brass tacks. Again, speaking for my organization solely, that we should determine the legal requirements, not just stemming from SB 72, but also included in SB 72, but other statutory requirements, constitutional requirements, and identify which apply to which utilities.
So you would like to see a decision now resolving those issues and not leave it open as we go. I mean, it just seems like the RTOs are evolving very quickly. Day ahead markets are evolving very quickly. Are you convinced there needs to be that legal and public interest assertion and jurisdiction at this time?
My suggestion, my suggestion would be that it would be very helpful to be clear about what legal requirements apply to which utilities, not resolving the substantive issues involved in that authority, but what will apply to whom can be teased out now.
Mr. Fagno.
I don't have the magic bullet here, but the public interest issue goes well beyond cost recovery. There's resource adequacy, there's resilience, there's compliance with the emission reduction obligations, there's interconnection issues, there are the continued viability of the ERP, Colorado's ERP process, in addition to what it's going to cost. So
Mr. Fagno, I totally get all that. But by the time you have a FERC filing, it's going to be impossible to meaningfully alter any of that. So the question is, what do we do on the front end to get this shaped right? And what do we need to do now on the back end to ensure the upfront discussions are meaningful, allow for meaningful participation? Because once the FERC tariff is filed, do you see there, I mean, the only choice in front of you is to withdraw or to participate. It's like you can't solve any of those problems. Or I struggle to see with how you solve any of those problems after the fact.
Well, I understand. I was addressing the back end issues. The front end issues, I think, are addressed in our step one, and combined, maybe compromised with the utilities step one of annual status reports. We would suggest enhancement of that, but that's where I think to develop a consensus, if you call it that, or approach one for input into the FERC filing would be appropriate and possible. On the back end, once it's in place, right? I agree. It'd be tough to change an approved FERC RTO tariff, but you still have to make a decision whether that is in the public interest. It may take a little hard swallowing. It may be cheering that they got everything right, but it still needs to be decided. The question is, who decides that? Is it the utilities deciding what's best for all, or is it the commission deciding what's best for all? Our view is the commission should decide that.
It'd be nice to get it set up properly up front, because that's going to be a brutal day trying to make a
All
public determination on something that you really can't change. So,
Which is why this is so significant. This
no,
is not,
believe me, I know. That's why I'm spending so much time in the regional processes and on this process. But I'm just struggling with what the after the fact process is.
I understand. I understand. We're willing to talk to the utilities some more.
Mr. Hefner.
Yeah, you know, at the risk of stating the obvious, I just want to add, you know, one entity to Mr. Fanyo's list of who might decide, which is all of this will go before FERC and there will be a public interest consideration there. That's a forum, and this is especially important to Tri-State, where stakeholders from Tri-State's other states can participate, not just its Colorado stakeholders. And that's the forum that in a lot of ways is really tasked with considering a lot of the issues that we've heard about, like governance and connection queues and transmission planning. And ultimately, they'll review whatever is filed there, you know, and give all stakeholders a chance to participate. So I just want to make sure we're including that as one of the list of deciders. It's not limited exclusively to the utilities and the Colorado Commission, important as this process is.
Well, I just say, especially in regard to interconnection queues, be careful what you ask for. Forecast some work to do. Would anyone else like to speak or share their thoughts and comments? Well, I just want to thank everybody for the dialogue and conversation. I think the gap seems to be narrowing on the front end. Perhaps we collectively can provide some guidance on the back end. It sounds like that may be timely. We'll put out some dates for the next round of comments. Advisors have suggested October 10th and November 7th. I suspect we're gonna find it necessary to schedule an additional hearing in this rulemaking, which will occur by a separate order. So unless anybody has anything else, I'll give one more chance. Until then, we are in recess. Thanks all for the great conversation, the dialogue, and all the help. Greatly appreciate it. And with that, we are in recess. Thank you. Thank you, sir.
Thank you, Your Honor.